Hello students, today we are going to discuss Turquand's rule. Before coming to that, we need to understand the doctrine of constructive notice. What do we mean by doctrine of constructive notice? As per section 399 of the Companies Act, any person may inspect or get a copy or extract of any document or any part of any document from registrar of companies on payment of such fee as may be prescribed. So, by the virtue of this section, outsider has access to documents of the company. Outsider dealing with the company is supposed to have knowledge of contents of these documents. And this is what we mean by doctrine of constructive notice. In simple words, outsider is presumed to have implied or constructive notice by virtue of section 399. This doctrine protects the interests of the company. Why is it said so? Because outsider can make out for which acts or transactions company can be bound and which acts and transactions shall not be binding on the company. Therefore, it's rightly said that this doctrine protects the interests of the company, because the company will be liable only for the acts which are binding on it. So this was regarding doctrine of constructive notice. Now let us discuss Turquand's rule. What is Turquand's rule? Turquand's rule got established as a result of landmark judgment of Royal British Bank versus Turquand. Let us discuss the facts of the case. Here, person holding the bonds of the company claimed payment and the company denied the payment. Company said that issuance of bonds required authorization of resolution since no such resolution was passed. Therefore, company is not liable to make payment. So, what did judge conclude? Judge concluded that company cannot refuse making payment on such bonds. Because by doctrine of constructive notice, the outsider is supposed to know the contents of the documents. It's fine, but outsider is not expected to go beyond a point. And outsider cannot inquire into the internal proceedings of the company. Outsider cannot look into what is happening within the closed doors of the company. Therefore, his interests need to be protected and he cannot be harmed for internal irregularities by the company. This judgment very rightly observed certain things and made such a conclusion. Let me further elaborate through help of example. For that matter, if company can escape the liability on the plea that resolution was not passed, then company could also, in similar situations, escape the liability in plethora of cases by taking different excuses. For example, it may say, okay, resolution was passed, but meeting in which it was passed was not proper because proper notice was not served, or quorum was not present, or for that matter, if some decision was to be taken in board meeting, company could have taken an excuse that since one of the directors on the board, his appointment was not valid, so board meeting was not proper. So one or the other excuse could have been taken by the company to escape the liability. That is why the doctrine of indoor management resulted from Royal British Bank versus Turquand's judgment, and it is rightly said that doctrine of indoor management is an exception to the doctrine of constructive notice and it protects the interests of outsiders. So by now, what all has been discussed? Yes, section 399 and thereby doctrine of constructive notice, and then Turquand's rule as established in Royal British Bank versus Turquand's case. And how does this rule protects the interest of outsiders? Now let us come to the last part of today's discussion, that is exceptions to doctrine of indoor management. Now in these situations, the protection under the doctrine of indoor management shall not be available. Let us discuss these situations one by one. Number one, knowledge of irregularity. So if a person dealing with company has knowledge of irregularity, then he shall not be given protection under doctrine of indoor management. Let us understand it with the help of renowned judgment, that is Harvard versus Patent Ivory Manufacturing Company's case. Here, company could borrow up to £1,000 without the consent of shareholders through a resolution. But for borrowing beyond £1,000, the consent of shareholders through a resolution was required. What happened in this case? Directors lent £3,500 to the company. Without resolution being passed in shareholders meeting. And here it was rightly concluded that directors cannot claim beyond £1,000. Why? Because they knew of the irregularity. And as an exception to doctrine of indoor management, those who know of the irregularity cannot claim protection under doctrine of indoor management. Now let us move to another point, that is negligence. What do we mean by negligence? Negligence means when a person does not exercise as much care and diligence as a man of ordinary prudence would exercise. So person who is negligent must bear the brunt of being negligent. He shall not be given protection under doctrine of indoor management. Anand Bihari Lal versus Deen Shah and Company. What happened? A person who accepted transfer of property from the accountant of the company was not exercising reasonable care. And therefore, he could not be given protection under doctrine of indoor management. Because here, the person who entered into such a transaction of transfer of property of the company by an accountant without possessing any power of attorney was being negligent. And the person who is negligent has to bear the loss for being negligent. He cannot be given protection under doctrine of indoor management. Now let us discuss another situation, that is forgery, another exception to the doctrine of indoor management. So you all know that forgery is null and void So, in Rubain versus Date Fingal Consolidated, where the share certificate bore forged signatures of directors, such share certificate was of no use, and person holding such share certificate could not claim shareholding as it was not binding on the company because of forgery. As I have told you that signatures on the certificate were forged ones. So no protection under doctrine of indoor management shall be available. So let me recapitulate. We started with section 399, Doctrine of Constructive Notice, and then we talked of Turquand's rule, which got established as a result of Royal British Bank versus Turquand's judgment. And yes, what did it give us? It gave us Doctrine of Indoor Management. And Doctrine of Indoor Management is an exception to Doctrine of Constructive Notice. Doctrine of Constructive Notice protects the interests of company, while the Doctrine of Indoor Management protects the interest of outsiders. Now, is the protection under Doctrine of Indoor Management available in all the situations? No. There are situations when protection cannot be claimed, and we have talked of 3 such situations, that is knowledge of irregularity, negligence and forgery. Whenever you watch videos, sit with paper and pen and try to make notes. Thank you. Have a nice day, and please keep in mind that my videos are only for educational purposes. Bye.